That's not going to change the facts. This was done in the open. Nobody had any expectation of privacy, be it the officers or Mr. Brown. And then, in addition to that, Mr. Womble has argued, and Mr. Williams has argued, that the names of the faces of the officers involved should be redacted. Certainly, that's within your purview, Your Honor. I know my clients have been asking for the information that is absolutely public record under 153A-98 with respect to the officers of the Pasquotank County Sheriff's Department, and so far has not been produced. And as Your Honor is aware in our brief, we list that information. The names of these officers are going to come out because they have to give that public information. I don't want to be back here in a public records fight. There is no legal justification to withhold the information that the General Assembly has made public. If that information is out, then there's no reason to blur the faces of the officers. I am deeply disappointed, and I completely understand of threats being made, but the release hasn't been made, and there are already threats. I don't know how releasing it is going to change whatever somebody's motivation is to make additional threats or that sort of thing. And Mr. Womble, I believe it was, or maybe, no, as Mr. Williams indicated, that somebody who didn't do anything wrong might be thrown into that pile of people that did. Well, releasing the video and seeing who did or didn't do what will work to alleviate that. Keeping it secret keeps the group of people unknown, and thus people are going to do what people are going to do. You experienced and you talked to us in chambers about the security. I'm looking around and there's security all around me. There was security. I couldn't even get parked near the courthouse. And if that's what needs to happen, that's what needs to happen. I know that you have a security detail. I know that others do. And if that's what needs to happen, that's what needs to happen. With respect to the pretrial publicity, the court is well aware, and I'm sure you have access to the School of Government's bench book on pretrial publicity, and there's a whole host of things that a presiding judge can apply to deal with pretrial publicity other than sealing a particular record. I can't speak to the wisdom of what they did, but through this process, the General Assembly has made these recordings, which are now in possession of the court for in-camera review judicial records. And there's a well-established First Amendment right for access to judicial records. And any order sealing those records must be reviewed under strict scrutiny. And we don't think that such an order could withstand strict scrutiny.
But I'm not being asked to seal records. I'm being asked under the statute whether to disclose records.
And I get that nuance, Your Honor. What I'm getting at—
That's not a nuance. That's a pretty exception or difference.
I understand that. What I'm getting at is the General Assembly has seen fit to put these records and make them judicial records. And thus there are First Amendment concerns that then attach to those records because they now are judicial records. And so by not releasing them, we think that's tantamount to a sealing order or perpetuating their being sealed. I don't mean to be pejorative in using the word nuance. I just think we have a difference of opinion, and I respect your understanding. The other aspect is the notion of delay. And if there's a First Amendment right to these recordings, that every day that they are not released harms that right, and it's irreparable. And so release, that weighs in favor of release. It appears, if I understand correctly, that the sheriff is in favor of release. The SBI doesn't take a position and doesn't object to it. The Brown family is in favor of release, and it's the district attorney and Mr. Williams and his unknown clients who are objecting to release. Our partner Hugh Stevens just finished an amicus briefing in a Supreme Court case here in North Carolina, and the name of it is not coming to me, but it involved an anonymous case filed in Cumberland County. Dovido. So there you go. Where we and others challenged the fact of proceeding anonymously. I don't think you can do that under North Carolina law. If Mr. Williams is making an appearance, he needs to identify his client for the court. Certainly I understand the practical reasons why he's not doing that, but I don't think he can do that under the Doe v. Doe case and comport with North Carolina law. If he identifies his clients, again, all of the reasons to blur and withhold the public records regarding the officers of the Pasquotank County Sheriff's Office fall away. And so I think that's important. There are no charges. Lastly, it is my understanding, and it's happened in the vast majority of these cases that I've done, is the recordings capture transmissions of law enforcement broadcast over the public airwaves. Under the public records law, that is unequivocally a public record, and it would take law enforcement coming to make a motion to have those not released, and they have to bear the burden of that. I don't believe any such motion has been made in response to our petition, and so I alert the court to 132-1.4C4. Your Honor, it wasn't argued here. I'll throw it so the court understands, because we may get there. I don't know the circumstances of what other first responders came to the scene. Others have argued that that it would be in violation of HIPAA. And here, law enforcement, we provided you in a brief, law enforcement are not covered entities. Their receipt of protected health care information in the discharge of their duties does not then lead to them. In addition, as I've said, this happened in the public view, I believe, in the public street. And so that there wouldn't be any HIPAA attachment, or that right of privacy isn't involved. Your Honor, as I started saying, the eyes of the world are upon us. And whatever these videos show, it will show them upon release. And people can draw the conclusions that they want to draw from there. I am not aware of any instance in North Carolina where the videos have been released, whether it's in an officer-involved shooting, a police chase resulting in a crash and a death, and a claim of excessive force, where a judge has determined after their release that a juror or a defendant couldn't get a fair trial, or and thus prohibited the district attorney from proceeding with the charges. I've not heard of a case where a court decides that the usual arsenal of things that a court has at its disposal to deal with pretrial publicity are ineffective because of the release of the videos. I don't say this because past experience doesn't necessarily predict the future, but I believe in these cases, we've obtained release in all of them. There have been redactions, and there have been blurring and things like that. One judge ordered the blurring of a minor child's face at a shooting scene. We've blurred people sitting in a booking area as somebody is being processed and that sort of stuff. What I urge you to consider, if you are thinking about those things, is that hard cuts on video lead to speculation. Minimal blurring to protect people who are truly uninvolved makes sense, and it doesn't lead to the speculation. We have also had situations where a witness is giving an officer somebody's cell phone number or other contact information, and we've muted those so that somebody's personal information isn't being given out. We're respectful of that. I think, not knowing what's on the video, I think you can craft an order that addresses those things but gives the public as much information as possible so that they can have a better understanding of what transpired here in Pasquotank County. Do you have anything to add? With that, Your Honor, unless you have any questions.
No, sir. Thank you.
Thank you.
All right. With regard to this this petition, Mr.
Your Honor,
Womble.
and I'll be brief because I know Your Honor appreciates brevity. I just don't like being misquoted. And I stood up here and I did not say that there was not a public interest. I clearly said that public accountability was a public interest. I said that. In this case, it is outweighed by my responsibility to conduct the orderly administration of justice and also the potential rights of the accused or potential accused to a fair trial. It's outweighed. As counsel clearly stated, people will, his words, draw conclusions. That's what they're going to do. They're going to form and express opinions about what they've seen. And the video is the ultimate issue. This is not a tangential video. I don't know the ones that he's described. He's described the 30 or 20 odd times he's been around the state to obtain videos. I don't know what they show. I don't know that they go to the ultimate issue. I have no idea. In this case, they do. So, potential jurors in the first judicial district will draw conclusions according to his words. They will form and express those opinions. It will hinder the orderly administration of justice, and it will hinder a fair trial. Counsel pointed out that no case has ever decided that you couldn't get a fair trial. Well, maybe they weren't articulate attorneys. Maybe they've held the trial somewhere where they don't have internet. I don't know. What I do know is that you cannot swing a skunk in front of a group of people and then ask them not to smell it. What I've asked is disclosure and release. I want Your Honor to give me an opportunity to complete this investigation, or the SBI to complete this investigation. Let me review it, make my decision, and then everybody can Monday morning quarterback me. Thank you, Judge.
Mr. Williams, you have anything you want to add?
Yes, Your Honor. Maybe there's something I'm missing here, and I miss a lot of times.
Mr. Williams, I don't think you missed that much.
I'm reading the statute 132-1.4a, and in subsection C, it names the people who are subject to disclosure, to whom it may be disclosed. They include a person whose image or voice is in the recording, a personal representative of that person, a personal representative of a minor or an adult under lawful guardianship, a personal representative of a deceased person whose image or voice is in the recording, or a personal representative of an adult person who is incapacitated. And then you go to the section F, dealing with release. And it says, notwithstanding the provisions of subsection G, a person authorized to receive disclosure. The media is not a person authorized to receive disclosure. A person authorized to receive disclosure, and then going on, may petition the Superior Court for an order releasing the recording to a person authorized to receive disclosure. The court shall determine if the person to whom release of the recording is requested is a person authorized to receive disclosure pursuant to subsection C. I submit to Your Honor that the press does not have standing and is not covered by this statute. At the end, if in fact you order release with a delay of 30 days, then they can get it when it's released then. And we would ask you to deny the request, and then I would renew all of my prior arguments on the county's petition as well.
All right, thank you, sir. Mr. High, I know that you were a party, your county was a part of this. Do you want to be heard with regard to this issue?
Just briefly, Your Honor, thank you very much, and good morning to you.
Good morning.
For the record, I'm Hackney High, and I'm here on behalf of the Perquimans County Sheriff's Office. And as Your Honor well knows, that is a county that's located adjacent to this county, just west of us. Elizabeth City is not within the jurisdiction of the Perquimans County Sheriff's Office, but shortly after the shooting, our office received a phone call requesting mutual aid assistance over here for crime scene preservation, for security, for crowd control, and the like. Due to certain budgetary constraints, we are a very small county, a very poor county. We don't have body cams. and none of the officers that came to assist local law enforcement were equipped with body cams, and we don't have any recordings of any of the events that we witnessed while we were here providing that mutual aid assistance. I just want to be clear for the record, there is nothing that we could release because we don't have cameras and there were no recordings made. And accordingly, I would just ask that the Sheriff's Department of Clemens County be released from this proceeding and any further obligations that it may have.
You want to be heard with regard to that?
No objection, Your Honor.
Okay, I'll grant that relief.
Thank you,
If
Your
draw an
Honor.
order.
I appreciate it very much.
Yes,
Thank
sir.
you.
All right. Anything else?
Your Honor, just to address Mr. Williams' point, I want to make clear that the court is aware that the petitioners, my clients, the 20 media entities, have petitioned under 132-1.4 subsection G, which is the general release provisions. F is reserved for those entitled to disclosure and law enforcement. A major difference between F and G is those petitioning under F, which could be law enforcement or those entitled to disclosure, don't have to pay the $200 non-refundable fee. My clients paid the $200 non-refundable fee. Other than that, Your Honor, I would also say that with respect to speculation, the speculation and conclusions are going to be drawn whether or not they're released. We believe that release will be, as I said, will quell the rumors or deal with rumors or vaccinate the rumors because it will be facts that will be released. Thank you, Your Honor.
All right. Yes, sir. Yes, sir.
Your Honor, I want to clarify one thing. Mr. Williams waived notice today, and I want to tell the court that he has, of course, not seen this petition today, and I want to apologize to him because I don't think we were sure if this was under F or G, and I do understand in G, so to the extent I caused any confusion to Mr. Williams, I apologize to him publicly, and this has just happened at a very quick, fast pace. I think we're all learning a lot very quickly. As to the public records request, I've been inundated with public records requests, and I understand there'll be a time and place, and we do intend to address those, but I can't tell you how many I've received. So, again, sorry to Mr. Williams, and thank you, sir. Thank you.
All right, well, certainly we're not here today on public record requests, so we'll reserve that for another day. All right, anything else? Yes, ma'am.
Your Honor, Amanda Martin, also for the petitioners with Mr. Toddy. As Your Honor knows, we served last night and have filed a petition asking the court to address the scope of the curfew that is embedded in the Elizabeth City declaration of a state of emergency. And as Your Honor suggested, I have spoken this morning with the city attorney. We have communicated about this, and I asked him if he was comfortable with me to put this on the record since he is not here, and he responded, absolutely, he is comfortable with this, that it's the position of the city that working journalists will not be subject to the curfew, and that he's not sure yet whether that will be through an amendment to the order or whether it will be through a working understanding and application of the existing order, but that he was comfortable with putting it on the court record that working journalists will not be subject to the curfew that is part of the existing.
All right, well, that's absent
Declaration.
something, there's nothing before me, an order, anything before me, so I don't think I need to comment on any of that. You can continue to work on it, and if y'all can reach a resolution, that's fine. If not, and we need to take action on your motion, then we can do so.
I don't think that will be necessary.
Okay. All right.
Thank you, Your
Okay.
Honor.
Thank you. All right, so here's what I'm going to do. I would like to be at ease for a few minutes. I'm going to go back in chambers and put these matters down and render my decision, and I'll be back out to do that in about 15 or 20 minutes, okay? And we'll be at ease until that time.
Your Honor, I don't mean to be presumptuous, but I did prepare with the caption for our petition, the Form AOC order.
I'm happy to take that and look at
There
it. Yes,
there
sir.
are 4 basic blanks.
All right, anything else before we, all right, we'll be at ease for about 15, 20 minutes.
Thank you, Your Honor.
Court be at ease about 15 to 20 minutes.
my bag. Let's take it back to back so I can, got all my stuff.
Testing, testing, checking, testing, testing, 1, 2, 3.
Hey, what's your password again? Is there anybody in the other courtroom? Is the W capitalized or not? Because I tried that and okay, that's probably why it didn't work, because I tried it,
Don't give me that
but
responsibility.
I capitalized it. Okay, thank you. Is there anybody over there?
No more talking. He's just gonna give his decision.
Okay.
I may be scolded by my sister-in-law because I did not
desk right now.
One-stop shopping.
I will tell you, that's part of the reason we do it this way, because
Then it's your headache, not yours.
I become the, herder of broken cats. Right. And, we did it in the beginning of COVID and told THHS we are trying to be a clearinghouse for you. And it's one of Amanda's good friends who's the medical director of the state, and we got basically go to hell.
You know,
Young
May
man,
see to come back to order.
Thank you. All right, I'm sorry that took longer than I thought, but I wanted to be sure that I had it like I wanted it. All right, first of all, I want to thank everyone for your arguments and your work in this case. I say many times, it's always a pleasure, court is always a pleasure when you have good lawyers. It just makes things better, and everyone who's before the court today did an excellent job and was prepared, so I appreciate that, so thank you very much for that. I'm going to begin with the 21 CVS 262, the media application for release of the recordings. The court, having reviewed the evidence, the petition, reviewed the brief filed by Mr. Toddy on behalf of his clients and all the attachments thereto, the court is going to find that with regard to the media's request for release, that the media is not a party contemplated under 132-1.4G for release. But if they were, and it was appropriate to release to them, the court undertook the analysis under G with regard to release of recordings and finds that there is evidence that the release would advance a compelling public interest. There is evidence that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. The court finds that the petitioner is not a person requesting or seeking to obtain evidence to determine legal issues in a current or potential court proceeding. The court finds, number 4, that it would reveal information regarding a person that is of a highly sensitive and personal nature. Number 5, that the release may harm the reputation or jeopardize the safety of a person. Number 6, that the release would create a serious threat to the fair, impartial, and orderly administration of justice. And number 7, that confidentiality is necessary at this point to protect an active internal and criminal investigation or potential internal and criminal investigation. The court therefore finds that that good cause does not exist for granting the petition of the media petitioners, and therefore that petition is respectfully denied by the court. That is my ruling. I'm going to prepare a order to that effect, and that will be prepared sometime this week, and I'll get that out to you in a formal written format at that time. All right. With regard to 21 CVS 261, the petition of the Pasquotank Sheriff's Department to release records to Khalil Farabee, who is the adult son of the deceased Mr. Brown. The court's going to find as follows, that this matter is properly before the court on the petition to release. To the extent that notice was required, notice was given by with Mr. Williams agreeing to hear the matter on behalf of his clients, but reserving his objection for lack of notice. The court has jurisdiction in this matter pursuant to GS 132-1.4A and all subparts. After hearing the arguments for the petition and the response from the district attorney for this judicial district and counsel for the respondents of all interested parties, the court finds as follows. 1, that the Pasquotank County Sheriff's Department is a custodial law enforcement agency, as that term is defined in the statute. Number 2, that Khalil Farabee is a personal representative under 132-1.4C4, and he's a proper person to whom the subject videos may be disclosed. The court considering the factors enumerated in subsection D of the statute. Number 4, that the court additionally considers the release of the video. In addition to disclosure, which the court finds is appropriate, I've also considered release under the statute using the same 8 criteria. And the court finds that, number 1, the release is a compelling public interest. Number 2, that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. Number 3, The person requesting release is seeking to obtain evidence to determine legal issues in a current or potential court proceeding. But number 4, the court finds that release would reveal information regarding a person that is of a highly sensitive personal nature. The court finds, number 5, that the release may harm the reputation or jeopardize the safety of a person by release. Number 6, that the release at this time would create a serious threat to the fair, impartial, and orderly administration of justice. Number 7, confidentiality is necessary to protect either an active internal or criminal investigation or a potential internal or criminal investigation. Based on those findings, pending completion of the investigation and any decision regarding the prosecution of the potential defendant, the court orders as follows: that the 5 body camera videos be disclosed to Khalil Farabee and his immediate family within 1 degree of kinship, and 1 attorney licensed to practice law in the state of North Carolina. That is disclosure. That the video be held from release for a period of no less than 30 days and no more than 45 days. And that that will allow completion of any investigation being undertaken by the SBI and by the district attorney's office in this county. Number 3, that the state is to notify the court when such investigation is completed, and the court in its discretion will consider at that time further release of the video based on the factors as they exist at that time. The disclosure of the video shall occur within 10 days, and the Pasquotank County Sheriff's Department is ordered to blur or redact all facial and identifying features of the officers shown prior to disclosure. That means facial features, name tags, any identifying information of those officers prior to disclosure. The court in its final order in this matter will specify the timeframes within which the video may be disclosed. In viewing the video, there were certain portions of the video that were conversations between officers, between superiors. I'm going to evaluate those videos, determine which portions are appropriate for release and or for disclosure, I'm sorry. And then we'll provide that in my order so that the videos can be properly prepared to be disclosed to the family. All that to be accomplished within the next 10 days. All right, that's how I'm going to rule. Anyone have anything they want to add or ask with regard to clarification?
Your Honor, I believe there are 4 videos rather than 5.
I'm sorry, you're right, there are. There's 5 files, but there's 4 videos.
Okay, all right, thank you, Your Honor.
And so I apologize, you're correct. All right, anything else?
Your Honor, while sitting here, I received an order from Ms. Hale regarding our request also that went to Elizabeth City Police Department. With your determination that my clients aren't entitled to seek release under subsection G, are you dismissing that additional portion of our petition as well?
Well, I didn't hear that portion of the petition, I don't believe.
Well, I guess what I'm getting at is, if we don't have standing, we wouldn't have standing for that. And
That would be my analysis, but I mean, I don't want to prejudge it because I didn't hear that portion, so.
all right, Your Honor.
All right.
Would Your Honor consider certifying your order for immediate appeal?
Under advisement.
Thank you, Your Honor.
All right. Yes, sir.
Will you be preparing that order as well, Your Honor? I'm sorry.
Yes, sir, I
Okay.
will.
All right, thank you. Major Wally, I'm sorry.
Your Honor, Major Wiley with the Sheriff's Office. I just wanted to clarify, it is 4 body cameras.
Until the next appointed time, God save the state and this honorable court, you may.
Remain until the sheriff lets you know otherwise, yeah.
We let you,
Thank you.
until the sheriff